So to understand what I'm about to say, let me take a step back and develop a concept. It's called preference or preferential transfer. The way to understand this is in bankruptcy, there are two big goals. The first is to give the debtor a fresh financial start. It has a laudable pedigree. It goes back to the Code of Hammurabi in the First Babylonian Empire. The Bible has a concept of bankruptcy. The ancient Romans had a concept of bankruptcy. It's explicitly mentioned in Article 1 of the U.S. Constitution. So it's a good thing. I wouldn't be doing this type of work if I didn't think there was a genuine benefit here. The other big goal of bankruptcy law is to make sure that all similarly situated creditors are treated equally and fairly. There are two ways in which debtors will sometimes violate this second big goal of treating similarly situated creditors the same. Number one, they won't list all their creditors in the bankruptcy petition. Well, you might say that's not such a big deal, is it? Well, if you don't mind spending time, free room and board in a federal penitentiary, I suppose it's not a big deal. But since you are going to be testifying under penalty of perjury that, among other things, you've listed all your creditors, you really do need to list all your creditors. Otherwise, you've committed perjury, and that is an imprisonable offense. The second way in which debtors will violate this big goal of treating similarly situated creditors equally and fairly is they'll make preferential payments to a given creditor in anticipation of bankruptcy. Perhaps they're hoping to curry favor with the creditor. It's my brother. Yeah, and when you did that, you treated your brother better than you treated other similarly situated creditors. When you do that, the Chapter 7 trustee appointed to the case is empowered to demand that that recipient of the preference disgorge the money, which will not be returned to you. Instead, it will go into a pot and be used to pay all your creditors on some sort of a pro rata basis. That's the general principle here. Now, there are some carve-outs in the preference world. One is for payments that you make in the ordinary course of your daily life. Just like clockwork, you're making that car payment. Well, you might say, wait a minute, I've just paid that creditor and I didn't pay these other creditors. Isn't that creditor getting better treatment? Well, again, the Bankruptcy Code has seen fit, or Congress in the Bankruptcy Code has seen fit to say, no, we're going to treat that one differently. Yes, you can keep making your regular car payment. Now, what you can't do is some large pay down. So let's say you decide instead of just making your regular monthly payment, you take a big chunk of money and you make 10 months worth of payments all at once. The 1 month, that was okay, but the rest of it, that was a preference that the trustee can undo. So that would not be a good idea. Notice, though, that what we're dealing with there is a secured debt, and they tend to be treated more favorably than unsecured debts in bankruptcy. A secured debt, for those who are unfamiliar with the term, is a debt that's secured by a tangible asset. If you don't make the payments, the creditor can retrieve the asset. And a car loan is one of those secured debts. So generally, it's not a good idea to start shoveling money at a credit card debt in anticipation of bankruptcy because that will be considered a preference. Having said that, there is sometimes a reason to make de minimis credit card payments in anticipation of bankruptcy. The reason is if you have relatively recent debts, they can create a problem. And so depending on the size of the debt, who the creditor is, and what's at work, we sometimes have people age those debts. Let some water pass under the bridge before we file the petition. And part of the aging process involves making some payments to that creditor, but we're not having large payments being made, minimum payments, or even if you can't afford the minimum payments, less than minimum payments. So those payments then are typically not going to be large enough to get the attention of the Chapter 7 trustee, because if the trustee is going to avoid those payments, it's a somewhat unusual usage of the word avoid, means to render null and void. If the trustee is going to avoid those payments and get the money back, then the trustee is going to have to spend money to do it. So if, let's say, you made $500 worth of payments to ABC Bank on a credit card debt, the trustee is not going to go after that. As a matter of fact, the cutoff in even reporting it is $600 total in the 90-day pre-petition period. But generally speaking, it's not a good idea to be shoveling money at creditors in anticipation of bankruptcy unless it's something like a car loan or a home mortgage. There, you want to keep making those payments just like clockwork, because if you don't, the creditor is going to move to repossess the car or foreclose on the home.